双语音标领航，注音阅读启蒙，叶兴阳有声读物。
Defence of Usury by Jeremy Bentham 1787. Defence of Usury. Shewing the impolity of the present legal restraints on the terms of pecuniary bargains in a series of letters to a friend, to which is added a letter to Adam Smith, Esq., Doctor of Laws, on the discouragements opposed by the above restraints to the progress of inventive industry 1787. Letter I. Introduction Khrushchev. In White Russia, January 1787. Among the various species or modifications of liberty, of which on different occasions we have heard so much in England, I do not recollect ever seeing anything yet offered in behalf of the liberty of making one's own terms in money bargains. From so general and universal a neglect, it is an old notion of mine, as you well know, that this meek and unassuming species of liberty has been suffering much injustice. A fancy has taken me, just now, to trouble you with my reasons, which, if you think them capable of answering any good purpose, you may forward to the press, or, in the other case, what will give you less trouble, to the fire. In a word, the proposition I have been accustomed to lay down to myself on this subject is the following one, viz., that no man of ripe years and of sound mind, acting freely, and with his eyes open, ought to be hindered, with a view to his advantage, from making such bargain, in the way of obtaining money, as he thinks fit, nor, what is a necessary consequence, any body hindered from supplying him, upon any terms he thinks proper to accede to. This proposition, were it to be received, would level, you see, at one stroke, all the barriers which law, either statute or common, have in their united wisdom set up, either against the crying sin of usury, or against the hard-named and little heard of practice of champerty, to which we must also add a portion of the multifarious, and as little heard of offense, of maintenance. On this occasion, were it any individual antagonist I had to deal with, my part would be a smooth and easy one. You, who fetter contracts, you, who lay restraints on the liberty of man, it is for you, I should say, to assign a reason for your doing so. That contracts in general ought to be observed, is a rule, the propriety of which no man was ever yet found wrong-headed enough to deny. If this case is one of the exceptions, for some doubtless there are, which the safety and welfare of every society require should be taken out of that general rule. In this case, as in all those others, it lies upon him, who alleges the necessity of the exception, to produce a reason for it. This, I say, would be a short and very easy method with an individual. But, as the world has no mouth of its own to plead by, no certain attorney by which it can come and defend this force and injury, I must even find arguments for it at a venture, and ransack my own imagination for such phantoms as I can find to fight with. In favor of the restraints opposed to the species of liberty I contend for, I can imagine but 5 arguments. Point 1. Prevention of usury. Point 2. Prevention of prodigality. Point 3. Protection of indigence against extortion. Point 4. Repression of the temerity of projectors. Point 5. Protection of simplicity against imposition. Of all these in their order. Letter 2. Reasons for restraint. Prevention of usury. I will begin with the prevention of usury, because in the sound of the word usury lies, I take it, the main strength of the argument, or, to speak strictly, of what is of more importance than all argument, of the hold which the opinion I am combating has obtained on the imaginations and passions of mankind. Usury is a bad thing, and as such ought to be prevented. Usurers are a bad sort of men, a very bad sort of men, and as such ought to be punished and suppressed. These are among the string of propositions which every man finds handed down to him from his progenitors, which most men are disposed to accede to without examination, and indeed not unnaturally nor even unreasonably disposed, for it is impossible the bulk of mankind should find leisure, had they the ability, to examine into the grounds of 100th part of the rules and maxims, which they find themselves obliged to act upon. Very good apology this for John Trott. But a little more inquisitiveness may be required of legislators. You, my friend, by whom the true force of words is so well understood, have, I am sure, gone before me in perceiving that to say usury is a thing to be prevented is neither more nor less than begging the matter in question. I know of but two definitions that can possibly be given of usury. One is the taking of a greater interest than the law allows of. This may be styled the political or legal definition. The other is the taking of a greater interest than it is usual for men to give and take. This may be styled the moral one. And this, where the law has not interfered, is plainly enough the only one. It is plain that in order for usury to be prohibited by law, a positive description must have been found for it by law, fixing, or rather superseding, the moral one. To say then that usury is a thing that ought to be prevented is saying neither more nor less than that the utmost rate of interest which shall be taken ought to be fixed, and that fixation enforced by penalties, or such other means, if any, as may answer the purpose of preventing the breach of it. A law punishing usury supposes, therefore, a law fixing the allowed legal rate of interest, and the propriety of the penal law must depend upon the propriety of the simply prohibitive, or, if you please, declaratory one. One thing then is plain, that, antecedently to custom growing from convention, there can be no such thing as usury. For what rate of interest is there that can naturally be more proper than another? What natural fixed price can there be for the use of money more than for the use of any other thing? Were it not then for custom, usury, considered in a moral view, would not then so much as admit of a definition. So far from having existence, it would not so much as be conceivable, nor therefore could the law, in the definition it took upon itself to give of such offense, have so much as a guide to steer by. Custom therefore is the sole basis, which either the moralist in his rules and precepts, or the legislator in his injunctions, can have to build upon. But what basis can be more weak or unwarrantable, as a ground for coercive measures, than custom resulting from free choice? My neighbors, being at liberty, have happened to concur among themselves in dealing at a certain rate of interest. I, who have money to lend, and Titius, who wants to borrow it of me, would be glad, the one of us to accept, the other to give, an interest somewhat higher than theirs. Why is the liberty they exercise to be made a pretense for depriving me and Titius of ours? Nor has blind custom thus made the sole and arbitrary guide anything of steadiness or uniformity in its decisions. It has varied from age to age. In the same country, it varies from country to country in the same age, and the legal rate has varied along with it. And indeed, with regard to times past, it is from the legal rate, more readily than from any other source, that we collect the customary. Among the Romans, till the time of Justinian, we find it as high as 12%. In England, so late as the time of Henry VIII, we find it at 10%. Succeeding statutes reduced it to 8, then to 6, and lastly to 5, where it stands at present. Even at present in Ireland it is at 6%, and in the West Indies at 8%, and in Hindostan, where there is no rate limited by law, the lowest customary rate is 10 or 12. At Constantinople, in certain cases, as I have been well informed, 30% is a common rate. Now, of all these widely different rates, what one is there that is intrinsically more proper than another? What is it that evidences this propriety in each instance? What but the mutual convenience of the parties, as manifested by their consent? It is convenience, then, that has produced whatever there has been of custom in the matter. What can there then be in custom to make it a better guide than the convenience which gave it birth? And what is there in convenience that should make it a worse guide in one case than in another? It would be convenient to me to give 6% for money. I wish to do so.
No,
Says the law. You shan't. Why so? Because it is not convenient to your neighbor to give above 5 for it. Can anything be more absurd than such a reason? Much has not been done, I think, by legislators as yet in the way of fixing the price of other commodities. And, in what little has been done, the probity of the intention has, I believe, in general, been rather more unquestionable than the rectitude of the principle, or the felicity of the result. Putting money out at interest is exchanging present money for future. But why a policy which, as applied to exchanges in general, would be generally deemed absurd and mischievous, should be deemed necessary in the instance of this particular kind of exchange, mankind are as yet to learn. For him who takes as much as he can get for the use of any other sort of thing, an house for instance, there is no particular appellation, nor any mark of disrepute. Nobody is ashamed of doing so, nor is it usual so much as to profess to do otherwise. Why a man who takes as much as he can get, be it 6, or 7, or 8, or 10% for the use of a sum of money should be called usurer, should be loaded with an opprobrious name, any more than if he had bought an house with it, and made a proportionable profit by the house, is more than I can see. Another thing I would also wish to learn is why the legislator should be more anxious to limit the rate of interest one way than the other? Why he should set his face against the owners of that species of property more than of any other? Why he should make it his business to prevent their getting more than a certain price for the use of it, rather than to prevent their getting less?
why?
In short, he should not take means for making it penal to offer less, for example, than 5% as well as to accept more? Let anyone that can find an answer to these questions. It is more than I can do. I accept always the distant and imperceptible advantage of sinking the price of goods of all kinds, and, in that remote way, multiplying the future enjoyments of individuals. But this was a consideration by far too distant and refined to have been the original ground for confining the limitation to this side. Letter 3. Reasons for restraint. Prevention of prodigality. Having done with sounds, I come gladly to propositions, which, as far as they are true in point of fact, may deserve the name of reasons. And first, as to the efficacy of such restrictive laws with regard to the prevention of prodigality, that prodigality is a bad thing, and that the prevention of it is a proper object for the legislator to propose to himself, so long as he confines himself to what I look upon as proper measures, I have no objection to allow, at least for the purpose of the argument.
Though,
were this the principal question, I should look upon it as incumbent on me to place in a fair light the reasons there may be for doubting how far, with regard to a person arrived at the age of discretion, third persons may be competent judges, which of two pains may be of greater force and value to him, the present pain of restraining his present desires, or the future contingent pain he may be exposed to suffer from the want to which the expense of gratifying these desires may hereafter have reduced him. To prevent our doing mischief to one another, it is but too necessary to put bridles into all our mouths. It is necessary to the tranquillity and very being of society, but that the tacking of leading strings upon the backs of grown persons, in order to prevent their doing themselves a mischief, is not necessary either to the being or tranquillity of society, however conducive to its well-being, I think cannot be disputed. Such paternal,
or,
if you please, maternal, care may be a good work, but it certainly is but a work of supererogation. For my own part, I must confess that so long as such methods only are employed, as to me appear proper ones, and such there are, I should not feel myself disinclined to see some measures taken for the restraining of prodigality. But this I cannot look upon as being of the number. My reasons I will now endeavor to lay before you. In the first place, I take it that it is neither natural nor usual for prodigals, as such, to betake themselves to this method. I mean, that of giving a rate of interest above the ordinary one, to supply their wants. In the first place, no man, I hope you will allow, prodigal or not prodigal, ever thinks of borrowing money to spend, so long as he has ready money of his own, or effects which he can turn into ready money without loss. And this deduction strikes off what, I suppose, you will look upon as the greatest proportion of the persons subject, at any given time, to the imputation of prodigality. In the next place, no man, in such a country as Great Britain, at least, has occasion, nor is at all likely, to take up money at an extraordinary rate of interest, who has security to give, equal to that upon which money is commonly to be had at the highest ordinary rate, while so many advertise, as are to be seen every day advertising, money to be lent at 5% what should possess a man, who has anything to offer that can be called a security, to give. For example, 6% is more than I can conceive. You may say, perhaps, that a man who wishes to lend his money out upon security, wishes to have his interest punctually, and that without the expense, and hazard, and trouble, and odium of going to law, and that, on this account, it is better to have a sober man to deal with than a prodigal. So far I allow you, but were you to add, that on this account it would be necessary for a prodigal to offer more than another man, there I should disagree with you. In the first place, it is not so easy a thing, nor, I take it, a common thing, for the lender upon security to be able to judge, or even to form any attempt to judge, whether the conduct of one who offers to borrow his money is, or is not of such a cast, as to bring him under this description. The question, prodigal or not prodigal, depends upon two pieces of information, neither of which, in general, is very easy to come at. On the one hand, the amount of his means and reasonable expectations. On the other hand, the amount of his expenditure. The goodness or badness of the security is a question of a very different nature. Upon this head, every man has a known and ready means of obtaining that sort of information, which is the most satisfactory the nature of things affords, by going to his lawyer. It is accordingly, I take it, on their lawyer's opinion, that lenders in general found their determination in these cases, and not upon any calculations they may have formed, concerning the receipt and expenditure of the borrower. But even supposing a man's disposition to prodigality to be ever so well known, there are always enough to be found, to whom such a disposition would be rather an inducement than an objection, so long as they were satisfied with the security. Everybody knows the advantage to be made in case of mortgage, by foreclosing or forcing a sale, and that this advantage it not uncommonly looked out for, will, I believe, hardly be doubted by anyone who has had any occasion to observe the course of business in the Court of Chancery. In short, so long as a prodigal has anything to pledge, or to dispose of, whether in possession, or even in reversion, whether of a certain or even of a contingent nature, I see not how he can receive the smallest benefit from any laws that are, or can be made to fix the rate of interest. For, suppose the law to be efficacious as far as it goes, and that the prodigal can find none of those monsters called usurers to deal with him, does he lie quiet? No such thing. He goes on and gets the money he wants, by selling his interest instead of borrowing. He goes on, I say, for if he has prudence enough to stop him anywhere, he is not that sort of man, whom it can be worthwhile for the law to attempt stopping by such means. It is plain enough then, that to a prodigal thus circumstanced, the law cannot be of any service. On the contrary,
it may,
and in many cases must, be of disservice to him, by denying him the option of a resource, which, how disadvantageous soever, could not well have proved more so, but would naturally have proved less so, than those which it leaves still open to him, but of this hereafter. I now come to the only remaining class of prodigals.
Vis.
Those who have nothing that can be called a security to offer. These, I should think, are not more likely to get money upon an extraordinary rate of interest than an ordinary one. Persons who either feel, or find reasons for pretending to feel, a friendship for the borrower, cannot take of him more than the ordinary rate of interest. Persons who have no such motive for lending him will not lend him at all. If they know him for what he is, that will prevent them, of course. And even though they should know nothing of him by any other circumstance, the very circumstance of his not being able to find a friend to trust him at the highest ordinary rate will be sufficient reason to a stranger for looking upon him as a man who, in the judgment of his friends, is not likely to pay. The way that prodigals run into debt after they have spent their substance is, I take it, by borrowing of their friends and acquaintance at ordinary interest, or more commonly, at no interest, small sums, such as each man may be content to lose, or be ashamed to ask real security for,